I'm in the middle of questioning a doctor in a medical malpractice case during the doctor's pretrial deposition. What does it mean when the defense attorney turns to his doctor, his client, and says, "I direct you not to answer that question, doctor"? What does that mean? What does it mean for me if the doctor won't answer my questions? If the doctor takes his attorney's advice and doesn't answer the question? You want to know? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, let's say you sued your doctor claiming that he was careless, causing you significant harm and injury. And now, during the course of your lawsuit, I have an opportunity to question the doctor in a pretrial question and answer session known as a deposition. This typically, in pre-COVID times, would take place in the doctor's attorney's office, in their conference room. But during COVID times, this will typically take place on a Zoom video call. Now, the doctor is there on the call, the doctor's attorney is on the call, I am on the call, and any other attorneys who may be part of this case as well, along with a court stenographer, we call them court reporters, who is there to record all of my questions and all of the doctor's answers. The doctor's answers are very important and they represent his sworn testimony, and you should know something else. The doctor's answers carry the same exact weight as if he is testifying at the time of trial in court in front of a judge and in front of a jury. So, what's the big deal? During the course of questioning this doctor, the defense lawyer jumps up out of his seat, not literally, but turns around and starts yelling and says, "Objection! That's an improper question, counselor. I direct the doctor not to answer that question." And now the attorney and I start having a legal argument. We start bickering about whether or not my question is appropriate, whether or not the doctor has to answer my question, and what are the implications for the doctor not answering my question. So what really happens here? Practically what happens? I'll tell you what happens. Obviously, the question I've asked the doctor has triggered an immediate response. And it's a response that's triggered either by one of two things. Either truly my question is inappropriate and the doctor should not be answering it, or my question is appropriate and the attorney or the doctor may be concerned that if he answers the question, it could destroy or significantly impair the defenses in this case. So let me give you an example. Let's say there are two doctors that you sued, and now I'm questioning doctor number one. And I turn around and say, "Hey doctor, I want you to tell me whether doctor number two rendered appropriate care and treatment to my client." And now the defense attorney jumps up and says, "Objection, counselor. That's an improper question. I direct the doctor not to answer." And then he cites some legal case that tells me why it's inappropriate for him to answer the question. And I will tell you, in that fact pattern, in that setting, yes, my question is inappropriate. Why? Because there is law in our state, in New York, that says that I can't ask doctor number one what he thinks of the care and treatment rendered by doctor number two that took place months later and is not directly related to the care and treatment rendered by doctor number one. In that instance, I can't ask him what he thought. Why? Because I cannot co-opt him. I cannot use him as my expert against doctor number two. That's the theory and the rationale why I can't ask doctor number one medical expert opinion questions about the treatment rendered by doctor number two. So how about this scenario? Doctor, I want you to assume that Mrs. Jones came in complaining of A, B, and C. Would you agree that good medical practice requires that you do X, Y, and Z? Objection! I direct the doctor not to answer that question. Well, guess what? The doctor has to answer that question. Why? Because that is an opinion question. In New York, I am permitted to ask the defendant doctor, the doctor whom you have sued, expert opinion questions. Now, why can I do that? I can do that because the law looks at this doctor as a medical expert. Because of his advanced training, because of his knowledge, because of his expertise, the law technically considers him an expert. And in that instance, I, as the attorney who represents the injured person, have the ability to now ask the doctor, first of all, what is good medical practice in this scenario? And then ask him whether it would be a departure from the standard of care to go ahead and do the types of things that he actually did for my client. Now, the reason why he may not want to answer that question, or his attorney may not want him to answer that question, if the doctor goes ahead and answers my questions and says, yes, if in this hypothetical scenario, as you described, I did X, Y, and Z, or I failed to do X, Y, and Z, then yes, that would be a departure from the standard of care. Now, if the doctor's attorney turns around and says, I direct you not to answer the question, you know what happens? Now we get into a brief legal argument, and if the attorney still refuses to allow the doctor to answer, I will say to the court reporter, mark that question for ruling. And now what does that mean? When I say mark something for a ruling, it means that months later, when I get a copy of the transcript back from the court stenographer, now I will know exactly where the issues were, where the doctor's attorney refused to allow his client to answer the question. And now it speeds things up for me. Instead of having to read the whole transcript, it might be hundreds of pages. Now I know, okay, on page 74, line 7, this is where it all started. And now I can make a formal written request to the judge to take action, to do something, to sanction the attorney, to sanction the doctor for refusing to answer a proper question. You should know, in malpractice cases in New York, the doctor is required to answer my hypothetical questions. And why is that? It's because the doctor believes one set of facts. My client believes a different set of facts. So now I'm asking the doctor to assume that our version of the facts are correct. And in that scenario, would you agree, doctor, that if our version of the facts are true, that failing to do X, Y, and Z would in fact be a departure from the standard of care? Correct? Yes. And doctor, if you had done X, Y, and Z at that time, do you have an opinion as to whether or not Mrs. Jones would have suffered the following injuries? And now he's going to tell me whether he does or doesn't have an opinion. I'm entitled to ask him those questions. So when a defense attorney turns around and says, do not answer that question, now he creates a problem for himself as well as his client, and if he repeatedly refuses to allow the witness to answer the questions, I will mark it for ruling and then move on to other topics and other areas, and then after the deposition is over, a couple of months later, I will circle back and now make a formal written request to the court to take action. So why do I share this with you? I share this with you because from time to time this comes up, and this is how we deal with it. You know, I realize you're likely watching this video because you wanted to see the beautiful scenery. No, I realize you're watching it because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.